Welcome to The Explainer. Today, we're tackling a question that's at the heart of, well, pretty much all of law and business. Somebody breaks a promise they made in a contract. What happens next? How does the law even begin to clean up that mess? And that question right there is our way into the whole world of contract remedies. The law doesn't just give up and say, oh well. It actually has this really sophisticated toolkit that's designed to fix the problem and protect the person who got hurt by the broken promise. So let's open it up and see what's inside. Okay, but before we just start grabbing tools out of the box, we gotta look at the blueprint first. What's the whole point of this system? What is it actually trying to do? All right, and this right here, this is probably the single most important thing to get. The main goal of contract law, it isn't to force people to do what they said they'd do. It's not about compulsion. It's all about compensation. The court's job is to figure out how to put the injured person in the exact same financial spot they would have been in if the contract had actually been performed. This idea is so fundamental, it leads to another huge rule. You almost never get punitive damages for a contract breach. Doesn't matter if the person broke the promise on purpose or by accident, the court's focus stays locked on one thing: making the injured person whole, not punishing the person who messed up. Okay, so if the goal is compensation, how do courts do it? Well, the law protects three different kinds of interests, and you can think of these as the three main tools in the toolkit that help a judge figure out what making someone whole even means in a given case. First up, and this is the big one, the one you'll see most often, the expectation interest. This is all about giving you the benefit of the bargain. It's about getting you that profit you were counting on, or the result you were promised. It's all about looking forward and saying, where should you be right now? Then we have the reliance interest. Now, this one looks backwards. Let's say you spent a bunch of money getting ready for the contract to happen. Well, this tool helps you get that money back. It's designed to put you right back where you started, back to square one, like the whole thing never even happened. And last but not least, there's the restitution interest. This one's pretty simple. It's about making sure nobody gets unjustly enriched. If you paid the other person or gave them something valuable and they didn't do their part, you get it back. They don't get to just keep the benefits without holding up their end of the bargain. Makes sense, right? So we've talked about the expectancy interest being the main tool, but how does it actually work? What does it look like in a real case? To really get it, we've got to talk about one of the most famous and kind of weird cases in contract law history. Yup, it's known as the hairy hand case. So you have this doctor who promises a boy that a surgery will give him a 100% perfect hand. But the surgery was a disaster. It actually made the hand worse, leaving it covered in hair. So the court is left with this problem. How in the world do you compensate the boy for that? Believe it or not, there's a formula for this. The court doesn't just guess. Basically, they start with the value of what was promised, a perfect hand. Then they add in any other losses that happened because of the breach. And finally, they subtract any money the boy's family might have saved because the contract wasn't fully completed. It's all about finding that exact economic gap between the promise and the reality. And this quote from the case just nails it. The court said, the damages weren't for the pain and suffering from the surgery. No. The damages were for the lost bargain. It was all about the difference in value between the perfect hand he was promised and the hairy hand he was left with. But hold on, this toolkit isn't just, a wild free-for-all. There are some really important safety rules. Even when there's a clear breach of contract, there are three big limitations on what the person who is harmed can actually get back. These three safety rules are avoidability, unforeseeability, and uncertainty. Let's break down what each of those means real quick. So getting damages isn't a blank check. First, avoidability. This means you can't just sit back and let the damages pile up. You have a duty to try and mitigate, to lessen the damage if you reasonably can. Second, foreseeability. The losses had to be something both parties could have reasonably predicted when they made the deal. You can't claim damages for some wild, out-of-the-blue consequence. And third, certainty. You have to be able to prove your losses with some reasonable evidence. You can't just throw out a speculative what-if number and expect to get it. Okay, so everything we've talked about so far ends with someone getting a check. It's all about money. But what happens when money just won't cut it? What if the thing you were supposed to get is one of a kind? Right. Like, what if your contract was to buy the Mona Lisa, or a very specific piece of land with a perfect view? No amount of money is going to get you that exact thing. In cases like these, the law has to reach for some very specialized equipment.
And that special tool is called specific performance. It's a type of equitable remedy, which is a fancy way of saying it's about fairness, not just money. Here, the court actually orders the other person to do exactly what they promised to do: hand over the painting, sign the deed. This is that rare, rare time where the court does choose compulsion over compensation. But courts are really careful with this. It's a powerful tool, so they don't use it unless they have to. You have to prove that money just won't work, usually because the item is unique and there's no substitute you can just go buy. And, super important, forcing them to go through with the deal can't cause some massive unfair hardship on them. All right, let's wrap up with 2 final tools in the kit. These are for some very specific situations you might run into. So sometimes 2 people making a deal know that if things go wrong, figuring out the damages is going to be an absolute nightmare. So what they can do is write a liquidated damages clause right into the contract. It's where they agree ahead of time on exactly how much a breach will cost. But there's a big catch. That number has to be a reasonable guess at the actual damages. It can't be some huge, crazy number that's just designed to punish the other guy. If a court thinks it's a penalty, they'll just ignore it. Here's a weird one. What if someone breaks a contract, but you didn't actually lose any money? Does the law just say no harm, no foul? Nope. In a case like that, a court can award nominal damages. We're talking a tiny amount, maybe just $1. It's the court's way of officially saying, hey, your rights were violated, even if there wasn't any financial damage. And that really brings us to the big picture, this whole system of contract remedies. It's this complex machine of rules, right? Expectancy, reliance, restitution, all these limitations and special tools, and it's all built to try and get a fair result. But it kind of leaves you with this big question, doesn't it? Does this whole toolkit, which is mostly about money, ever truly fix what was lost when someone broke a promise?